if you have been here before, you know you are going to have to participate way more than that. How are we? Thank you. Okay. Thank you all for coming along tonight and giving up some time. My name is Sarah De Jong. I had a slight name change since last time, and that was the part I thought I would definitely trip up on. I was like, I'm absolutely going to announce my name wrong. But we got over that hurdle, guys, so now we can continue. Thank you for coming along to Better Call Sarah. Before we get started, I would like to do a quick acknowledgement of country. In keeping with our reconciliation commitment, it is culturally appropriate and important to acknowledge the First Nations people as the original inhabitants of the land on which this event is taking place, and recognise the remarkable country north and south of the winding Brisbane River, home of the Turrbal and Yagara nations. Following cultural protocol, we pay our deep respects to all elders past and present, as well as our emerging leaders of tomorrow, and thank them for their wisdom and guidance. I'm going to introduce my incredible panel in just a moment, but before we do, I just need to do a few quick housekeeping notifications, announcements, whatever we call them. This evening, because we're going to talk about admissions, we're going to hold questions from the audience until the end. So we're going to run through some information for you in a little bit more structure than maybe we normally do at these events to try and get through some really important information and hopefully answer a few of those burning questions for you right up front. We will then try and hold some space at the end for questions, but we have so much information to give you. So if we don't get to questions, all of our panel members have agreed to stay back tonight for drinks and dinner and to answer all of your questions one-on-one. Bathrooms, if you need them, are on the other side of the elevators, and in the event of a fire, please look for one of our QLS staff who are currently standing at the back of the room and follow all of their instructions. Okay, now that that's out of the way, let's jump in. Because this topic is so broad, normally we would do 2 guests, but we have brought 3 along tonight who have kindly agreed to give up their time. I am joined tonight by Amy Hayes, who is the Director of Licensing, Operations and Policy with the Queensland Law Society. Sherrieanne Hutchins, who is the Senior Solicitor of Licensing at the Queensland Law Society, and Chloe Parsons Pope, who is who's one of our Queensland Law Society councillors for the 26-27 years. She is a commercial litigation and regulatory solicitor, and she is part of our early career cohort. So nice and early. So she has done this admissions process fairly recently. So she is your go-to for how it worked for her. Okay, let's jump in. Chloe, I'm going to throw straight to you.
Amazing.
Okay. See, this is the participation I need. Otherwise, it's just me. Okay. Why do admissions bodies and the profession place so much emphasis on disclosure and integrity at the student and graduate phase?
I would say in terms of disclosures and integrity for the profession at the graduate and student stage, it is important that we recognise that there are some risks when entering the profession. So in the event that you do have any sort of disclosures that are akin to dishonesty, public trust, we want to know about it before you get into the profession. It is a risk mitigation strategy to make sure that the profession, we iron out any of those bumps. It's also a protective mechanism because there's a duty to the court, a duty to our clients, and a duty to the profession. So we need to make sure that as a profession, we know those risks first up.
Amazing. So it's not a Better Call Sarah episode unless I ask for a little bit of audience participation, so I'm going to do that now. We asked you all at registration to give us a little bit of information about where you're at in your careers. So which of you are still at uni and where you might be in your uni journey, if you're at PLT or if you've already gone through this admissions process and you're just joining us for some networking. What I want to start with is very quickly, by a show of hands, who has a pretty good idea about what the concept of admission is? Put your hand up if you think you're pretty comfortable. Cool. Put your hand up if you've heard of it, but it's just a word to you. You're not really sure what it really looks like. Yeah, great. Okay. Let's start there. So admission is effectively the process of joining the profession. It is at its core an application to the Supreme Court. So when we talk about our clients, eventually as lawyers who might want to commence litigation or whatever the case may be in court, it is an application to the court for admission to the role of solicitors. So in practical terms, we do our PLT. We then start that process, and it's kind of you guys correct me if I'm wrong, but it's like a 28 to 30 day process, starting with like a filing and originating application. So saying, I have done everything that I need to do. I've been to uni, I've done my PLT, and I would like to be admitted. And then there is a series of dates where you need to file additional information, references, copies of your documents from court transcripts, court, uni, all your transcripts, all the way through to your final admission day. Your admission day is an application before a Supreme Court judge. There's 3 judges generally that do your admission, and you will have someone from the profession as your mover. So they will stand up in court and give some information briefly to the court about you and apply to move you. The court will listen to that. They will nod and you will be moved into the profession. Then you go outside and you sign the roll. That doesn't make you a lawyer yet. You then have to go through a process of obtaining a practicing certificate if you would like to practice as a solicitor, or you need to go and do the bar course if you would like to be a barrister. So what we're talking about tonight are those kind of 2 quite distinct processes. The process of admission, so from originating application through to signing the roll, and then that next step of going on to get a practicing certificate if that's where your journey is going to take you. Did I miss anything catastrophic?
So the timeframes have extended. So instead of 28 days to file your initiating application, you've now got 42 days. So it just extends and it pushes all those timeframes out. Amazing. Same with you need to file an affidavit of compliance. You used to have 14 days. That's also been extended. So just be really sure of your timeframes. But that's the only thing I'd say. Yeah.
Perfect. Which is great, because when I went through it, it was a really stressful 28 days. It was like you were on a stopwatch and you couldn't start part of that application until you'd done the previous part. So in addition to working full-time, running a family, whatever it is you were doing in your own life, it was quite... So it's great to hear that we've kind of listened to that and extended that out. Wonderful. While I'm on you, Sherry, I'm going to ask you a question. While we're talking about the admissions process, what does full and frank disclosure actually mean in practice, and what are some of the common misunderstandings that law students might have about it?
Yeah, so it's really common that applicants for admission will misunderstand full and frank disclosure. So what I used to explain to applicants when they would call and ask what is full and frank disclosure, I would simply say to them, look, the board weren't there when that event occurred, so you need to provide enough detail that they can pick that up, read that, and then go, okay, this is exactly what happened. And they don't have follow-up questions or anything like that. So that's the level of detail you want to do. Often I would see applicants cherry pick information or leave information out, and then they, their thought process would be, I'm going to put that in my affidavit of compliance. Don't do that. Don't wait until then, because the admissions team are very thorough. They will pick that up, that it's, that you've popped a one-liner in your Form 7, and it can cause delays to your application. So just be really full and frank from the outset of your application. It's in terms of things to do, don't do. I think that's kind of just from the beginning. When in doubt, disclose. So if you're concerned, disclose it, although use your common sense. So for example, I had an applicant who disclosed that in primary school they pinched $5 from their mum's purse and went to the tuck shop. Okay, that's not a disclosable matter. So, use your common sense, but at the same time, if you are over concerned, there's nothing wrong with over disclosing. So, yeah.
I'm going to go a bit off script. What, for our audience tonight, would be some of the things? So when I went through, the common things that everyone kind of had in their mind were kind of academic misconducts, parking tickets, driving offences, Centrelink overpayments.
Yep.
What are some of the key, it won't be an exhaustive list, so this is not legal advice, but what are some of the key things that we think about when we're talking about disclosure that you would need to start thinking about if you were doing your application?
So in terms of suitability matters or what?
Suitability matters, sorry.
Yeah. So obviously criminal offences. So a common issue that applicants will have is they won't disclose a dismissed criminal matter. So any criminal matter, disclose it. Same with academic misconduct, which you said. We would get applicants saying, oh, well, the allegation wasn't substantiated, therefore I don't need to disclose it. Disclose that. Also, infringements, council fines. So if you've, had an animal wandering at large, disclose that. Any late lodgement of tax returns, mental health. So if you've had a diagnosis, doesn't matter if it's 2 months ago or 20 years ago, still disclose it. So I think, it's really any matters that can. There's like an element of deception as well. Mm-hmm. So any disciplinary matters. So if your employer's dismissed you for something, if it's, not if you don't pass probation, but if there's a disciplinary matter. So, yeah.
And between you or Amy, whoever's best placed to answer this, do those things differ between the between the admissions stage and the practicing certificates stage?
Did you want to answer that one?
Yeah, I can answer that one. I'll jump in. So the matters themselves are very similar, and when I talk about the Act, I'm talking about the Legal Profession Act, and that is the Act that governs the admissions process, the practicing certificate application process, and all of those things. So when someone is applying for admission, the Admissions Board will be looking at the suitability issues in Section 9 of the Act. Then when we come to practicing certificates, we're looking at both Section 9 and Section 46. So although there's quite a lot of crossover, those things do differ quite a bit. So we look, I guess, upon the practicing certificate side of things from a risk perspective, as Chloe mentioned earlier as well, and that's what we do. So if you have, though, declared a matter on your admission, and then you come along to the society and you're asked in your application about suitability issues, you don't have to redisclose that, but you do have to mention that you had that suitability issue and include the date. So they're very similar types of matters. So what Sherry's already sort of alluded to, but in addition, you might have things like corporate insolvencies, criminal offences, or failures to adhere to court orders. And so I would say the suitability matters that are sort of more geared towards the practicing certificate application stage are more so matters that will sort of they're sort of more geared towards the types of issues that would arise for practitioners in the course of legal practice. Specifics, we'll get into that a little bit later, but I think that's probably the key difference, is that the admissions ones are maybe a bit more general, and then the practicing certificate application suitability issues are more geared towards things that arise within legal practice.
Perfect. Thank you. We're all learning something tonight, even those of us that have gone through that process. So, Chloe, I'm going to go back to you. You've recently gone through this process. So, for our audience tonight, if a student has something to disclose, let's go back to the admissions process for now. What practical steps could they take to prepare their application, especially, I guess, focusing on how do you gather information or evidence? What do you need to do, I guess, to disclose that? Is it just writing it in a document, or what do you need to substantiate it? And I'll get the others to jump in if there's anything extra there as well.
So once you've identified a suitability matter that you need to disclose, it depends on the matter itself. If it's, say, a Centrelink overpayment, you would need evidence of that and evidence that it's been either repaid. If it was an electoral roll offence, you need a copy of that as well. So you need some sort of evidence to show that it has been resolved, or you've repaid it, or it has been dealt with. So if you're looking at obtaining any sort of evidence from a government authority, I would request it in advance. So speaking from experience, I had an electoral roll offence. I didn't vote when I was 18 because I didn't think it mattered. I realised it does matter. So I had to disclose that in my application to the profession. I needed the receipt saying I'd paid, and I sort of disclosed it was an administrative fee, but it had been dealt with, and it was in, I think, my first year of uni, and it wasn't current. So I would, definitely think about evidence gathering, because it does take time if you need to speak to particular, if it's regulatory bodies, if it's from the court ordering transcripts. I think you need to plan in advance. I know on the QLS website they do have admission kits that sort of set out all the forms, Form 1, Form 15, those, the steps that you need to take. I think it's really helpful to use that website, and if you're working at a firm, speak to your mentor or speak to your mover, someone who's gone through the process recently. I would use an example if they have similar disclosures, see how they've worded it, see how they've, pleaded the rules. I think that's quite helpful in what I did back when I was admitted.
Thank you. Does anyone have anything to add to that? Because I know that will be a burning question from our audience. Yeah. I think, though, Chloe, something that you touched on, I think among law students, there's a real fear about suitability matters and having to disclose something and how that's going to be looked at. I think it's important to realise there are lots of people in our profession, lots, that have had a variety of suitability matters that get disclosed. You guys see them all the time. You can probably speak to this more than me, but I think you would, if you're an adult and you've lived life, you've probably got something to disclose. I did not drive safely when I was younger. My speeding tickets, there was a few of them, and let me tell you, putting them on paper all together at once made me a little bit anxious. But even Centrelink over payments, when you're a student, if you're trying to navigate how Oz Study works and you're working at the same time, and I think it's important to take a moment and realise it's not something to be scared about. It's just something that you need to be proactive about. Is that fair?
I think that's 100% fair. The regime is not in any way meant to be punitive. It is protective. So there's a lot of case law around that to say that, we're not trying to punish people. We're not trying to stop people from entering the profession who, but for, a speeding ticket, would otherwise be considered a fit person. So that's definitely not what we're trying to do. What we're trying to do is to understand what the risks are associated with suitability issues that are known and to mitigate those risks. So the Society has a variety of different ways that we might do that. So we can, in terms of practicing certificates at least, we can agree undertakings with practitioners to say, for instance, if you've had a driving history, well, we'd like to keep a tab on that. Can you provide your driving history to us for the next 3 years? That's something we might ask. We might impose a condition on a practicing certificate, say, for instance, that a medical report might need to be provided just to satisfy us on an ongoing basis that the person is fit for practice. And then in the most extreme cases, we might suspend or cancel a practicing certificate. But that's not what we want to do. It's not what we set out to do. We want to have a thriving profession, but we also need to mitigate the risks. And with that, I should mention is the overall objective of the Act is to protect consumers and the public generally from harm, essentially. So that's essentially what we're trying to do as the regulator. Yeah.
Perfect. Thank you. Sherry, when I have been doing some reading and some research for tonight around what questions I guess our audience might have, one of the things that keeps coming up is this distinction between a clear recommendation and a qualified recommendation. What does this mean? What's the difference and why should we care?
So this is one that scares applicants a lot, usually towards the end of their application if they're to receive a qualified recommendation from the board. So a clear recommendation is that the board have recommended you as fit and proper, and there's no need to provide any written statements to the court for them to further consider. A qualified recommendation is still a recommendation from the board that you are fit and proper, but there are some, for example, suitability matters that should be brought to the court's attention, and how they do that is through written submissions that would be prepared by your mover. So really not a scary thing. It's an extra step that needs to be taken, but the board are recommending that you're fit and proper. So it's still a really, really good outcome. But I would say if you do get that call that you've got a qualified recommendation, you jump straight onto the phone to your mover and you say, hey, this is what's happened. Do you have time to do my submissions? Because you don't want to delay your application by leaving it to last minute. But that's the biggest difference. But it's not a scary phone call when you get that phone call. If you get that phone call, it is still a really positive outcome. Yeah.
Perfect. Thank you. I'm just having this horror moment where I realise I think two of my questions are duplicated, and I'm just trying to work out if there's a difference between the two. Did you work this out too?
Mine, because I kind of struggle to make them different. But I've still got material. We can go there.
Okay, all right. Well, we're going to ask maybe a slightly similar question, but maybe not. Let's see where this takes us. Let's go back to talking about disclosure obligations and the distinction, I guess, between admission to the profession and the practising certificate. And maybe it's more broadly than just the suitability matters.
Yep.
Maybe that's the distinction we meant.
Yeah, I mean, so what I did want to touch on was sort of a little bit of a deeper dive into some of the suitability matters and what they are. So when we're looking at Section 9 of the Act, we're looking at things like good fame and character and whether somebody can carry out the inherent requirements of legal practice. And those concepts, they aren't defined anywhere in the Act, but they are referenced continually in the case law. And so for the society, we have to consider what that means in the context of what someone might have done, essentially. So when we're talking about things like character, we're talking about honesty, integrity, candour, all of those sorts of things. And as you all should already know, they're inherent requirements for legal practice, and they demonstrate good fame and character as well. Candour is intrinsically linked, and so is honesty, to disclosure. And this is the term that continues to come up again and again and again, and will continue to come up throughout this seminar. And that is that full and frank disclosure of what you might have in terms of suitability matters, and that is despite any sort of self-interest that we might want to preserve, or any sort of embarrassment as well. And that is the true test of character, is to make those disclosures even when it's a little bit uncomfortable, embarrassing. That is what really shows the depth of character and will go a long way to the society considering how to potentially deal with a matter. So if someone's been upfront versus not, that is a huge difference. So as Sherry said earlier, if there's any doubt, disclose, always disclose. So we've got those couple of good fame and character, inherent requirements of legal practice. They also comprise things like trustworthiness, adherence to the law and to authority, and all of those sort of virtues that, moral sort of virtues that one should have in entering the legal profession to uphold the administration of justice. So then we move into so that's on the admission side, and then when we move into practising certificates, we've got all of those things plus all the suitability matters in Section 46. And as I mentioned earlier, they differ slightly but are quite similar. The only other things that we then have to think about are our adherence to the Australian Solicitors' Conduct Rules and our fundamental ethical duties there. So we've got that, and then once we have a practising certificate, we're also subject to statutory conditions. So statutory conditions include things like if you are charged with a serious offence, that you disclose that to the society, or if you're convicted of an offence, you disclose that to the society. So as a solicitor, as a practising solicitor, if you have any matters like that, they are disclosures that you must make within certain timeframes. So just taking a step back, when we go from our admission to applying for our practicing certificate, firstly, we go off to the admissions board and we make our application there, we're admitted. And then once we're admitted, we come to the society's licensing team, make an application, or records team, make an application, and we consider that application. As part of that, practitioners or lawyers, as they're known at this point, not quite legal practitioners yet, they have to make a declaration in a form which talks about the suitability matters. And I think it's really important to stress at this point that that declaration is a legal document. And if you are later found to have disclosed something incorrectly, or you've misled in that declaration, not only have you done that thing that you've got that suitability matter, you've also then got the issue of providing a false declaration, which is really, really, really serious. So please don't ever do that. Always disclose, always better to put it in there than not. So yeah, there's that difference there between the admissions and the practicing certificate, in that there's that higher duty. Once you're admitted and you're a lawyer, you've got all of the suitability issues, plus you've also got the statutory conditions that you have to adhere to for your practicing certificate, and the Australian Solicitors Conduct Rules. So there's quite a bit more to think about at that point.
Is anyone else overwhelmed yet? Because I don't have to do this again and I'm overwhelmed. So. Okay. But for all of that, if you're all feeling a little bit like I am, there are kits, right? So when we're talking about all the different form numbers and what you need to do and getting character references, there's help available, correct? On the QLS website. Where would we find that?
Yeah. No, sorry. So on the QLS website, there's an admission kit. There's also guidelines. There's also a number you can call to speak to the board if you have questions. They obviously cannot give you legal advice. The society can't either. There's a society ethics centre or department that you can speak to about any sort of matters. You can ask for it to be confidential. But obviously that's not legal advice. They're not giving you legal advice, but they can assist you in, full and frank disclosures, what they're looking for. I made use of the board's number and called the board and asked them questions about the process, about the forms. Yeah, there's a lot of information out there. It's just accessing it and speaking to people who have done it recently.
Perfect. So before I throw to the audience for some of their questions, what from each of you is what's the one thing that you want this audience to take away tonight? If they listen to nothing else that we've talked about, what's the one thing that you would tell them about this process?
That the board want you to be admitted, and there's just a certain process and steps that you need to take in order to get into the profession. But at the end of the day, we want competent, qualified lawyers. It's just a process that you have to take. And it may be a bit emotional, it might be a bit embarrassing, but everyone, 98% of people get through it and they can look back at it and be like, what a time. But yeah, it's just something that we all have to go through in order to become a legal practitioner.
Great. Sherry?
I was going to say the same thing, so I'm going to pivot. Totally fine. Look, admissions is really exciting. I know it can be really overwhelming and scary, but it's an exciting time. So the advice I would say is use it as a trial run for your practice in the future. So prepare your application thoughtfully and professionally, and deal with the board staff professionally and thoughtfully. And yeah, use it as a practice run. You're about to enter the profession, and I would say prepare your application as though you're in the profession. Yeah.
And to try not to overwhelm. What I would say is it's not so much what you do in terms of your suitability matter, it's what you do next. So you can have the suitability matter, you can disclose it, you can be forgiven. We are all human, we all make mistakes at times. That is completely expected. I think, as you mentioned, Sarah, you know, you go through life and you're going to get speeding tickets and you're going to have things that crop up. It's just part of what happens. Don't try and hide it, be upfront. It's all about what you do next and not trying to hide it that really matters, despite, you know, some professional or personal embarrassment or uneasiness. It's key. It's the way forward. It must be done. So that's my key piece of advice.
Thank you. And I know when I went through it, you know, and maybe you guys were the same, it really did feel like the last hurdle. Like it was, you know, you go through uni and everything can be super abstract, and you're kind of reading from textbooks and you're interpreting case law, and, you know, that's not practice, you know, and then you all of a sudden, even PLT gives you a little taste of what it's like, but that whole process of you're filing an originating application, you are walking it to the Supreme Court registry. By the way, how you staple your document makes a difference. All of those things are, you know, if you catch your registry staff at the end of a very long day and you haven't stapled, my gosh, you will know about it. But I think it's the final hurdle. It's the culmination of everything that you've learnt, that you have learnt to write, that you have learnt to interpret the Legal Profession Act to find those relevant matters. It is really a pulling together of everything that the last 4 or 5 years has brought you to this moment. And I think, to your point, it's so worth it. Like, I don't think there's a single lawyer that I've spoken to that's gone, yeah, look, my admission was okay. You know, it's really exciting. And to stand before 3 judges or justices of the Supreme Court and have them looking solely at you while they listen to words that are spoken solely about you and your friends and family and loved ones watch. Our profession is really traditional and it's really powerful. Like, I think it's just a moment that for all your stress as you go through this, it's really worth it at the other end. And I think something I always say to take away is if you're in doubt about this stuff, like Chloe said, you know, ask people, ask our boards, there's so much help available. Ask other lawyers. You know, everyone in this profession is really busy and they're really time poor. I'm yet to see a lawyer, though, respond to a student and go, not today, could you ask someone else? They will make time. Even if that time is responding to an email to you at 10 p.m. at night, they will make time for you because it was important to them.
I'll just say something on that as well. And 100%, there are so many generous lawyers out there that are willing to give their time to review and all of that sort of stuff. What I would just say and just give you a word of advice, a bit of caution, is that there are some practitioners out there that I think, and you can probably speak to this a little bit more, Sherry, around sort of overcharging or charging exorbitant fees for admissions in cases which is really, really not necessary. So I think I would just let you know that sort of stuff does happen out there, and just to be cautious if you're thinking about engaging someone to move your admission as to sort of what they may be charging. There's plenty of practitioners that'll do it for nothing. So that's just something to think about. I'm not sure if you've got anything to add to that, Sherry?
No, not really, but look, I agree with you. A lot of practitioners are honoured to be approached to be moving an applicant. So, you know, if somebody's going to charge you thousands of dollars, maybe look elsewhere.
I will do it for free.
Yeah.
You can contact me on LinkedIn. Yeah. Don't take my advice, but I will move your admission. Okay, let's go to questions from the audience. We've thrown a whole lot of information at you. Some of it might have had context and landed, some of it might not have because you've all had different experiences to date. But does anyone have a question while you have these people sitting in front of you?
With advocacy, is that a disclosable issue?
In what sense?
So, for, say, Lyme's disease, like things like illnesses that haven't been recognised.
Okay. As in that you're an advocate for people? Or?
Yeah, and like I wrote to the senators and things like that. Do we need to disclose all those type of...
Right, so kind of going along... the word's right on the tip of my tongue. You know what I'm talking about. But there's a disclosure register for it.
Right.
Lobbying, but it's not lobbying. It's advocacy.
That's what I thought.
Yeah,
I thought it might be
concept,
controversial.
But not quite as, yes, okay.
I haven't seen it disclosed before.
Oh, okay.
So I think the odd thing, if in doubt, disclose. But if you're not party to like a civil proceeding or a disciplinary proceeding,
Right. It may come about though, so I'm
okay.
just
In that
a bit
case, if you are
concerned.
concerned that may come about, it is
Right.
better just to disclose things.
Okay.
No harm in over disclosing.
Okay.
Yeah.
And the second question, if you've got a fine and then you appealed it because there was a mistake, is that disclosable as well? Was the mistake on their side?
I think the same thing. You tell your story. You
Okay.
know? Yeah. It's there. It's there. The outcome's there. Fill in the blanks. Disclose.
Oh,
Yeah.
okay.
Yeah.
That's it.
Thank you. Like I said earlier, we've all got suitability matters. I mean, I'm very honest about mine, right? And I think I'm very honest about it because people are so anxious about it. One of mine was a Centrelink overpayment, and it was a fairly significant overpayment. So on paper, even the lawyer that I was working for at the time was like, "Ooh, you're going to have a problem with this." Because it's Centrelink, you've got to go through like a freedom of information application to, get all the records and stuff like that. So my situation was pretty simple. I'd had a baby and I was working casually at the time, so I quit my job. So when I went to Centrelink for my maternity pay, they ask you how much money you'll earn in the year. And I said, look, $30,000, because that was kind of like what my maternity pay was going to be. I had my baby in June. Come February, I was feeling pretty okay. Baby was doing well. I went back a couple of days a week. So at the time, I called Centrelink and said, hey, my income's changed. Because I then very shortly thereafter went back to work full-time. Talk to me about that story separately. I have other advice for you on that. But it effectively said, Centrelink went, look, you were actually never eligible for family tax benefit this year. So for the whole year, I had what appeared to be a pretty gross overpayment. I went to Centrelink and I said, can you tell me the date that I called you and declared my change? And this was, my daughter was 5 or 6 when I got admitted, so years later. Centrelink were able to give me that information because they have to maintain their records, and I was able to say, here was my payslip, this is the first date that I went back, here's the date that I told Centrelink. So on paper, looked really scary, everyone was telling me it was a big deal. It wasn't a big deal at all. So you just tell your story.
When would it be worthwhile to seek legal advice in respect of an admission? Like, what are the circumstances where you might consider speaking to a lawyer before instigating the admissions process?
I mean, I'm going to defer to the panel, but I would go as soon as you think that you might want to. Like, if you've got something, say you've been charged with like so I was a criminal lawyer, right? So say you had a really serious criminal charge and you'd assaulted someone or whatever. If you're concerned about that, and you're going to keep accruing HECS debt, and then you're going to pay $15,000 for PLT to maybe not get an outcome, like, why would you sit anxious about that for a couple of years? Like, if you're unsure, ask, raise the question, call the QLS, call the ethics line, start to assure yourself. And maybe there is more evidence for you to gather, that instead of waiting 21 days out of admission until that, start gathering it,
To your point, talking to the lawyers in your circle, talking to, the profession, looking at case law, is there any sort of similar circumstances? I would say if you are worried about it, that is when you start talking to a lawyer, a barrister. I know the College of Law has a few barristers that help with particularly painful admissions. Have a chat to Scott Malcolmson. Those sort of people in that space that will move your admission for free, and it will be easy, painless. They'll do submissions on your behalf. If you think it's going to be something that requires, a barrister to get up and draft submissions and advocate on your behalf, then I would start speaking to people in your circle. It is not as scary as what it seems, and it's over within the admission day. So,
great.
If the board comes back with a qualified recommendation, does that mean at that point you need a barrister to move you instead of a solicitor?
Not always. It depends on the circumstances. If it's a very senior solicitor that knows the disclosure back to front and they're willing to draft submissions, that's perfectly fine. If it's a criminal offence, I would engage a criminal barrister. They will be able to draft beautiful submissions and, plead the case perfectly rather than asking, someone of 2 years PAE.
So many questions. Okay, we'll keep moving around. We've got plenty of time, but if you could just wait for the mic at the back.
My question kind of follows on from that. As somebody that knows that I need to make some disclosures, I guess how obviously getting a qualified recommendation is fairly common. Is there something to be proactive about? Like, if you think it will probably lead that way, is there things you can do early on in the piece to get prepared for that?
Absolutely. So you can, if you've got a hunch that it's heading that way, you can reach out to your mover as soon as possible and say, hey, look, I think that I'm more than likely going to get qualified. Are you prepared to, write submissions on my behalf? Because between the board giving you that recommendation and the court sitting, there's not a whole lot of time. So that's why I say if you get that call, get straight on the phone, because there's not a lot of time and you don't want to have to adjourn over something like submissions. It happens. There's another, admission around the next month or so. But look, if you are thinking it's heading that way, absolutely get in touch. Prior to your, application, if you are concerned about your suitability matters, it's always really helpful to demonstrate, insight. So when you're writing your material, make sure you're, explaining what steps you've taken. So if you've done some ethical training, that's great. Explain that. If you've done some professional mentoring, because you've spoken to your partner and they've said, and you've said, look, these are my suitability matters. Are you placed to give me some mentoring? And you're upfront with them. That's great. Put that in your application. Get some references. Just demonstrate that you are taking active steps so that this kind of, conduct wouldn't be repeated in the future.
Yeah, so kind of show that you're aware that it's definitely a suitability matter and you've done everything you can to try to address it proactively.
Absolutely. It's really important. I think Amy was kind of touching on that is, making the disclosure and then having that insight. So, being able to disclose it properly is saying, yep, I know that was a problem. I'm up front. Here it is. And this is what I've done to try and overcome it. Yeah.
I also think there's a lot of anxiety, and not knowing what any of your, potential disclosures are. I would strongly encourage, if you're quite anxious about your disclosures, to actually go and read some case law, because there are some people, wonderful people in our profession who had really serious disclosure matters who got admitted, and their admission process maybe was delayed, or maybe it took a second time, or maybe they were told to take more time and take more steps. And those people still practice today. They've not had any issues in practicing. They're wonderful contributing members of our profession. So if you're quite anxious about yours, really go and start doing some reading, because I am often faced with law students who come to me really anxious about something, and when they tell me, if they wish to tell me what it is, I'm like, oh God, you'll be totally fine. Just take a deep breath, talk to people. So talk to people, be trusted people that are relevant, because what you might be anxious about might not be worth losing sleep over. Still disclose, that doesn't navigate any of this, but don't lose sleep over any of this stuff, because there's always more than one way to get through this as well. There's a lot of hands over there on the edge.
Hey, so you guys mentioned parking or speeding fines. To what age or how many years would you place within the scope of disclosure?
Oh my God, all of them, first of all. All of them.
Yeah.
I've done a lot of talking.
There's no real cut-off, so just add them in. And when you have a practicing certificate, the obligation continues. So a good case to look at is a recent case that was considered as a Legal Services Commissioner versus, where am I? And O'Brien. Legal Services Commissioner O'Brien, and that was around disclosure of traffic offences and disclosures or lack thereof disclosures, particularly in light of a historical context, which was around the fact that they were on notice that such matters should have been disclosed. So definitely continue to always disclose those matters, and on admission, certainly go back as far as records began with that sort of stuff. Yep.
And with that, in the process, is there like steps to be taken if you just completely forget to mention something? Like, say, like it was like a parking fine, but like it happened so many years ago that you just had entirely forgotten about it, but they raised that. Is like it escaped your mind or you forgot about it a defence as such, or does that happen?
I can jump in. Yeah, I mean, and that does happen because, you know, we forget, and that is just something that does happen. We recently had a matter where a practitioner had been admitted and they had forgotten to disclose a particular matter. They did so then. They went back to the admissions board and they disclosed that matter, and it didn't affect their admission. But what they did do was then when they came to apply for a practicing certificate, they disclosed that whole scenario and they said, hand up, I completely overlooked this. I didn't disclose it, but then I did retrospectively, and they said it was all good. So I just want to let you guys know. And great, we're not going to do anything with that. So it's just about knowing so that, again, we can mitigate the risks if there are any.
And just on that as well, we talked about, you know, getting evidence. So, you know, for your driving history, you can obviously go and download through the QPS what your driving history is. Parking tickets are slightly different. Like if you remember it and you've got something and you want to disclose it, but don't go and ask the Brisbane City Council for a record of every parking ticket that your car has ever received in the last 5 years. Like there's a balance to that as well. So not saying don't disclose, just to be really clear, asterisk to all of this, but when you say parking ticket, just, don't stress yourself about everything. Don't make yourself sick over it, right? That's probably my point, is if you know about it, disclose it, but if it comes up later, disclose it then.
And that's a really good point. And actually, thank you for prompting me, because it was something I meant to mention earlier, is that this O'Brien case that I mentioned, it's authority for the fact that as practitioners, and I know that's slightly different to when you're coming to be admitted, but you can keep it in mind for later on. As practitioners, the expectation is that someone should be able to self-assess what is appropriate and not appropriate to disclose. So, you know, when we've got parking tickets, that sort of thing, you don't necessarily need to disclose each and every parking ticket that you get or each and every speeding offence that you may get. However, what you do need to disclose and always be mindful of is that an accumulation of these types of offences demonstrates a disregard for the law, and that is problematic. So that is when we would want to know. So say, for instance, you got 2 speeding fines in the course of 6 months. Yeah, we'd want to know about that. But if you got 1 speeding fine in 3 years, potentially not. Again, if in doubt, disclose, but one of the duties that a solicitor, or one of the things a solicitor should be able to do, is have that kind of insight to be able to self-assess and say, is this something that I need to disclose or not? So, yeah.
Thank you.
Sorry, we'll come down the front and then we'll go the back. I love your shirt, sir. It's excellent.
So, quick question. Is there anything that you can think of that even if it was fully disclosed might still prevent you from being admitted?
Lots of things.
I was like, I have so many answers.
The shorter list would be the other way around.
Look, I don't even know where to start with that. Yes, I think there are... It's every case on its merit. It's like cases that come before court for sentencing. There is no kind of formulaic, if you have this plus this, you're not getting this. It's everything on its merits. And like the girls have said multiple times, it's a risk approach. So a really common one that I've been asked about at previous events is mental health. where people might go through uni and maybe we're really anxious, we're really stressed, and we get a anxiety diagnosis. Thank you. Nothing's working tonight. From the doctor. You know, it's not a simple matter of that in the last 12 months. There's absolutely no. It's everything on its merits. It's what happened around that. What does that mean moving forward? It doesn't mean anything moving forward. And that's where the people at the board will assess all of that. So it's around putting all of that information. Like, there are absolutely things like really serious criminal offences if that goes to your character and to the way that our society expects our profession to be, behave and turn up in the world. There are absolutely things that, yes. That being said, though, it is well documented that there are people who have been to prison for drug trafficking offences and are wonderfully contributing members of our legal profession now and who are leaders in our legal profession now. So again, I could sit here and go, drug trafficking, that's not the answer either. You know, it's everything on its merits.
A good example of that is, so for two reasons I mentioned this particular matter. A recent matter in 2022, Jashneel Prakash. So that applicant disclosed a serious wounding offence, and he initially did not provide all of the supporting documentation, so he didn't provide the sentencing remarks, and when the court did obtain those, they felt that he had underdisclosed the matter, and when they had read the sentencing remarks, it was a very serious matter. So that was back in 2022. He's recently, I believe, been admitted early this year, so the court, you know, case by case, like Sarah was saying, but they did, you know, they did consider it a very serious offence, but passage of time, they've revisited it, 3 years later? Maths isn't helping me right now. 3 years later, and that applicant is, you know, has now been admitted. Second reason I mentioned that one is that's a really good case to read to scare the pants off you in terms of make sure you disclose everything. So when we would get applicants going, I'm scared about disclosure, I'd say read that case. Read that case. Don't do that. Make sure you provide all the supporting documentation. Don't, you know, cherry pick or anything like that. So, but it's also a really positive case too because that applicant's now been admitted. So, yeah.
Sorry, I had one more question as well. You mentioned before about the kit being available. Does the kit have, I guess, a bit of a list in there of things that you can look at to kind of jog your memory or to help prompt you with anything that you should consider that you might have forgotten about or anything like that so you don't accidentally forget anything?
I believe so. There's also from the Queensland courts, the Law Admissions Consultations Committee, LAC. They have posted or published basically suitability matters and what that means in LPA world. So it goes through, you know, criminal matters, corporate insolvency, and lists them all. Yes, yeah, the admission kit does say what suitability matters you need to disclose, but it's not an exhaustive list. You do need to make a fair judgment call on what to disclose, but I think the overarching theme from today is if in doubt, you do disclose it.
No, I'm taking one more question. I'm going to get in trouble for this. I have time for a very short one. If you have a very quick question, I'm happy to take one more question. Yep, we've got one hand up just here. Oh, Ken, no pressure. This has got to be a very short one. Oh, Jen? Okay.
Hey, what do you do if the disclosures are longer than 7 years ago? Because one thing I'm having an issue with is getting information from like a long time ago, longer than 7 years. And after 7 years, a lot of organisations destroy documents. So what do you do in that situation?
I'm happy to be corrected by the experts, but I believe you have to make all reasonable attempts to obtain the document. So you've exhausted all avenues, you've contacted all people, and they don't have it. A statement saying that this evidence has been destroyed is something that you can annex to the affidavit showing that those records they've gone with the floods or whatever.
But would you attach like your reasonable efforts, like?
You can depose that in the affidavit and in your Form 7, I believe, detailing I've made every possible, investigation.
But would you attach the letters that say, we don't have this information because it was longer?
Yep.
Okay.
Yep.
And yeah, just make sure you're deposing to those steps you've taken, so fleshing them out. If you sent an email, attach the email, say that you've sent it. If you've made that call, obviously you're not going to have a record of that call, but stepping out so that whoever picks up that affidavit can see that you've made, all efforts and you just simply can't get the documents. Yeah.
Thank you.
Okay. That brings us to an end in terms of our formal component of tonight. If you could please join me in thanking Amy, Sherry and Chloe for taking the time tonight. Thank you so much for coming along. We've got some dinner for you. My wonderful panel have agreed to stay around, so come up if you've got individual questions that you don't kind of feel comfortable asking in this space. My one small request of you tonight is at the end of the evening, we will send you a very short survey about tonight. I'm really hoping you can take a few minutes to fill it in. What we're trying to do is form what you would like to hear about if you'd like to come along to some of these future events, or contact us directly. We really are looking for what is it you want to know about your profession before you join it. So thank you so much in advance for taking the time tonight. All right, let's eat.
Round of applause for Sarah as well for her incredible emceeing of the panel. There's a lot of time spent outside of hours, and I think, everyone has learned amazingly from Sarah today.
Thank you.
Who do you turn to? Who do you call for answers?